Yo.
Yes, sir.
What's up, guys?
Yes. This DJ will kick the floor in 3, 2, 1.
On the troll.
Hello and welcome to Mzansi. We're back again. It's that time where we have to tell you what happened in court. Today, we had a trial within a trial and a trial within a trial eventually, which was regarded as a huge trial within a trial. Initially, it was not introduced as a trial within a trial within a trial.
Oh, so after Advocate Mnisi brought it up?
Yes. Yes. It was after Mnisi brought it up that it became what we call it today.
And the judge said it's intertwined.
Running away from the fact that he didn't consider that, and probably we shouldn't be surprised that tomorrow we are going to get something that looks to favor or looks to rule for the state, because I don't think that they sort of expected that an advocate, which is Mngomezulu in this case, would introduce himself in this manner. And considering the fact that he was not prepared for this,
For the argument.
it was just, from the bar, as they say, he was just using his experience in terms of work, and also I would say the title that comes with being an advocate. So that's how they dealt with an issue. So, Emily, you are going to elaborate for us and tell us what happened there.
Hi guys, welcome back to the Mzansi Reality YouTube channel. Thank you so much for joining us yet again for another deliberation of what happened throughout the day at the Senzo Meyiwa trial. Thank you so much for joining us, and thank you guys for your continued support as well. I know we've been having a lot of issues, and you guys are still coming to hear what we have to say and to also share your opinions, because later on we open the lines so that you guys can express yourselves about what happened today. And please don't forget to like, share, comment, do the right thing.
Yes. There seem to be a reduction of likes these days. Most probably because we
don't emphasize them anymore.
Yes,
guys, you still have to press the like button, you still have to engage, you still have to comment, you still have to share the video with other people who may be interested in the case.
Yes.
Yeah, that's all really, basically just to support the platform. But anyway, welcome. The defense was expected to come out guns blazing against an alleged damning confession recording, which the state said of accused number 2 Bongani Ntanzi, to have it not considered part of the evidential material. So the state had prepared heads of argument, and the state said that it had prepared heads of argument on the admissibility of the audio recording taken by Magistrate Veiws. Advocate Baloyi said that they will deal with the characterization, admissibility, and issues that must be proven by the state. Now, Advocate Baloyi seemed very, very prepared, even using cases to back up what he was saying. I was like, where did he get all of this time to read all of these cases regarding the admissibility part? And yet, he got the recording recently.
Well, I guess
Y'all don't find that suspicious? You don't?
I guess he doesn't sleep preparing for this case.
No, even if he doesn't sleep, those were way too many cases that he quoted to back up his arguments, considering the fact that he told the court that he only got a hold of the recording recently. So yeah, we're gonna let it go for now and just focus on what he was saying. Advocate Baloyi presented the state's head of argument on the admissibility of the recording of the alleged confession by accused number 2 Bongani Ntanzi, and Baloyi said, "We mentioned that the defense has challenged the admissibility of this statement, stating it was made under duress and was not signed. We mentioned that Grunier made the recording. She testified she did not inform the accused and his legal representative, and she was doing it out of personal choice and safety and not for official purposes." Baloyi then said the defense case has not yet been put to Magistrate Grunier. We submit the authenticity of the recording is being challenged by them. Baloyi said Grunier indicated the recording was not meant for official use, but made out of practice to safeguard herself. We submit the recording is relevant. We submit the recording by Magistrate Grunier is real evidence. Baloyi said that there will be no fail of justice if the recordings are admitted. Then the judge said, what is the state's view of the infringement of the accused's right to privacy? And Baloyi said, in this instance, the recording is the electronic version of what the accused was telling the magistrate. All the magistrate did was to keep a record of those proceedings. It was a recording of what the accused was telling the magistrate out of his own volition, his own will.
Yes, and jumping the gun right there, because that has not been proven. So mainly why the judge should have clarified that this is a trial within a trial that now has actually created the need for a trial within it also. Because now Baloyi is jumping the gun to say that this was out of the person's will, which has not been proven in this case, because the defense is still standing on a position of under duress and whatever that was promised. Allegedly.
So he also stated a case, I don't remember, is it Motata? And here he says that the recording from the phone, regarding the originality of the recording, he stated that the case where the recorder or the recordings were transferred from a phone to their personal computer, and the phone was irreparably damaged.
So the originality of that is still in question, because it has been processed further to now a work laptop, which was not the original source of that. So there's a secondary source that also needs to be looked for. So in this case, what would compel the judge to rule against this case? Let us look at why it is important for the judge to actually rule for the defense, actually, in this case. See, cases that are done in high court, they become part of the literature as they're being used now and then. As you can see, they are using them. So you are mandated as an officer of law to actually leave. I don't know, for the lack of a better word, leave a proper literature for others to learn from, good reference. Because if you go on and rule for the state on this one, maybe because, as people feel, some allegedly, that this could have been a predetermined destination. But this one, I would like to believe this was not predetermined. Why I'm saying this? Because I don't think they would have preempted the situation where they would have to deal with a trial within a trial in a trial. So they would have maybe if there was such a thing, prepared for the first one, but I don't think the second one was going to be the good. But then my worry is that it was never declared initially as such. Such is worrying for someone who says they apply the law to the T. So if you apply the law to the T, then you should have been able to actually apply the law up to such an extent that if you realize that now we have actually moved away from this first trial within a trial, you were supposed to declare such. Because under Baloyi, Baloyi is under assumption that he's still dealing with a trial within a trial. So a victory on this could have amounted on a victory on a trial within a trial, the initial one. Which is not. They're dealing with admissibility now of the
New
audio
evidence
in a trial within a trial. Should that thing be thrown out
or not?
And the amount of I would say of weight that lies on that recording. That's why yesterday I did say that I do not think that in their sober mind they did not want to submit that thing. They just waited for an opportunity to come, and then they had to discuss that. Hence, it was brought by the judge, and then questioning the defense about it, and then now they created the need for it. So this was, to me, it looks like a strategy that was in motion, but they were never ready for. Maybe they were never ready for this much resistance, and the resistance that comes more from now from accused number 1 and 2.
Yes,
it seemed it was gonna be a walk in the path as usual, where we do not have to discuss the nitty-gritties and the merits of what ought to have happened about the recording. Yesterday we did in fact submit that the rights of this person were actually trampled upon because he was recorded without his knowledge.
Yes.
And what makes matters worse is to hear that the statement might be lacking some information, which makes me even think that in fact it was a situation that was actually already there, prepared. It was going to be a sneakery way of bringing it on board. So that was it. And then from bringing it on board, then obviously it becomes a walk in the path to win this trial within the trial. But now this resistance has created a new problem that needs a ruling with the eyes of the people watching to see that actually what is going to happen in that court. And remember, this becomes part of the literature now. The judge is mandated, as much as they are retired, to leave such a legacy for himself, and also for the people of this who work with these cases and laws, because one day he will be referenced. So if he takes a wrong decision now, one day someone will use this case as a point of departure to actually go and trample on people's rights and record it anyhow.
Yes. So yeah, it was very interesting, and it will set the standard. It will mean that now people can record each other without each other's knowledge, and it can be used in a court of law.
Where
so it's a very heavy burden on his shoulders. He has to make the right decision.
They say it's I'm quoting from my head. It's Act 55, right? Of criminal of section 217, right?
Something
on
like
section
that.
4, which clearly states that, which sounds like it says it's okay to do whatever with this when you get this information. And then there's section 2, which sort of would protect that and be against that, which Baloyi undermines in saying that no, as long as there's no harm that is going to be done with this thing.
No. Advocate Mshololo in fact used it to make her argument. She did use it.
Yeah.
And she did argue very well I felt very proud. Section 217 of Act 51 of
1977. Yes. Which is read in line with section 4. There's section 4 and there's section 2, which one has a potential of, and the judge did ask about it. If you accept section 4, there's a potential of you undermining the rights of people. And what we have heard is that the rights should outweigh what we call ethics or whatever that they put, that Baloyi wants to submit is part of. Yes.
Constitutional rights are above. So yeah, it was very interesting. And in this portion, I also felt like the judge was assisting Advocate Baloyi to strengthen the state's case for some weird reason with all of these questions that he was asking him at the beginning.
Yes.
It just felt off.
No, it didn't even feel off. In fact,
it just felt like he's helping him.
In fact, Baloyi, in submitting that section 4 of that Act 55 of 1977, he even quotes the judge to say that it does not, in fact, seek to undermine Section 2, as the judge argued yesterday in their debate. And so to show that there is a bit of, for me, for the lack of a better word, the cohesion, that sounds like a bit of collaboration and work with, because the arguments are coming from, is dealing with the arguments that were made by the judge. And those arguments, in making those arguments, it was not sounding like he's actually putting them in a neutral position. And obviously, this is my opinion. It was just prepare. It's like a message, It sounded like a message, but we could be wrong. And I mean, this is a court of public opinion here. Yes. And the judges are not expected to tip any other participant. In this case, it would be Baloyi and the defense. But it does feel that most of the time the things that are said, and Baloyi comes back to submit on that line, and even going as further as bringing some of the cases that were caught in that debate, in the so-called debate, to support his statement.
And I even heard the defense quote a different case. Was it, I forgot the case, but it seems like the judge is not really clued up on that one, because he doesn't comment much on that case that they were using.
Is it Magwaza one?
Magwaza.
Yes. You see what we have learned from this judge is that he seems to be more clued up with the past, where before people had right, as Mngomezulu would rightly say so, that to focus on such, even the judgments that were made during that time should be taken with caution.
Yes.
Because the rights of certain people were undermined at the time.
They didn't exist.
Yes, they didn't exist. So to come with those cases and with your chest out as if everything was normal, some of those decisions were taken under circumstances that did not allow certain people to actually have rights.
And that's the problem right there.
And that is the problem right there, yes. And you look at these acts that were created, even the one that was created in 1977, surprisingly, it still is referred as an act. Most of these acts are acts that are referred as acts that were created in 1977, which then is a failure of the people that are in charge of this country, that we say they are part of the democracy. To have such not being revisited and looked at, to tighten the bolt that maybe could have been let loose for a certain reason, to find certain people guilty all the time. It is worrisome, because today we get to argue about such things and argue as if those are things that we should take as the decisions that were made in a normal circumstances, in what we may call a perfect world. which is not the case. Yes.
So, Advocate Baloyi said that it has been raised up to this point that the recording is false. And he said, we submit that the state should be allowed to play the recording. The judge said, you say the procurement was not in conflict with the law. And Baloyi said, yes, the RICA Act. The judge said, as I recall, it says a person who was monitoring the recording may not apply to a judge. And Baloyi said, we'll submit that she was merely recording. And the judge said, not for the purposes of committing a crime. And Baloyi said, that is so, my lord. And the judge said, what is the state's view on the invasion of the privacy of accused number 2 by such a recording? Now, here I felt like the judge was helping the state to strengthen their argument, and it just rubbed me off the wrong way.
He wanted the answers. You see that's a problem. You must work all the corners. So in this case, he couldn't have let that question go, because if he was to rule for the state, then he would need to justify why that happened. So he wanted to basically soliciting the opinion of the state based on the law, so that yes,
he's giving it away.
Yes, you need to.
He's more planning to rule with the
he
state.
He could have let it go and said in his ruling against the state, said the state did not give him enough when it comes to the rights of the accused that was recorded. And one way of doing this is basically just letting these people bend themselves as much as they can and become a judge that seems a bit more neutral. But some other judge would like to provoke some thoughts. We have seen this with Advocate Dalimbofu when he's dealing with the matters where you are expected to you are invited to comment on something that seems to be a cloud that could be left if the judgment was to be given, and you are the judgment is in favor of you. Just clarify that part. It's okay. It does happen in the court of law.
So Baloyi said, we submit that the recording is an electronic version of what the accused was telling the magistrate. There's no room to say his privacy was infringed. Baloyi then said he was in front of the magistrate telling her, and all she did was to keep a record. The accused was on his own volition telling the magistrate. So the judge said, what was the primary evidence? And
so
Baloyi
just a warning, we are about to get to that time of buffering. I'm not sure if it's going to happen. It's about 2 minutes to 11, and that's an hour where we normally have a problem. Just a warning in advance.
So Baloyi, the judge said, what was the primary evidence? And Baloyi said the primary evidence, as we indicated, is the laptop Ms. Grenier recorded the proceedings on. As we understand, the laptop is still available. So the judge said, so you are saying this court cannot rule on the matter without listening to the evidence? And Baloyi said, yes, my lord.
And Baloyi undermining the primary source of that evidence, the original source of that evidence, and making the second source the original source, just because it was furnished by the state, or just because it was a work laptop. I don't know. It still becomes a problem because we are transferring evidence. Now it can be edited. There's a lot of things that can happen on that laptop.
So Advocate Mngomezulu did a stellar job today. His arguments were backed up by cases that he had read on, and it was almost like he was recalling from his head. I mean, it was very
he was
refreshing.
Addressing the court from the bar. Literally, he didn't prepare anything. It's based on the experience that is.
It was
Yes.
refreshing. It was refreshing. So this court is seized with an inquiry to make a decision on the admissibility of a statement allegedly made by accused number 2, which the defense objects to, amongst other things, because of duress coupled with it not being made in his sound mind. Mngomezulu said the duty of the magistrate was to take down the confession in writing. There is no extension provided in the Act for other duties. Mngomezulu said in relation to the audio, such rights were not afforded to him with regard to that recording. The witness, Ms. Grenier, went to the extent of violating his rights. We maintain a right has been infringed. Mngomezulu said it is their submission that the court can come to a decision without having listened to the recording.
Yes.
He says no rights were explained to the accused and his rights were infringed. Such evidence should be excluded where a right is infringed. This tape recording should be excluded as it will hamper the administration of justice. Mngomezulu basically said that Ms. Grenier, who admitted that she didn't tell Ntanzi or anyone that she was recording the alleged confession, violated Ntanzi's rights by not disclosing that she was recording him. And one has to wonder, if accused number 2 knew that they were being recorded, who's to say that they would have told the truth? Or they would have been in a safer space to express themselves as to what was actually happening,
Yes.
instead of what they were being pressured to say.
Not necessarily to say the truth by if you want to look at it like that when it
Yeah.
comes to the state, because the state can tell me what you are seeing, but what I'm seeing here, it says there was a bit of disconnection.
Guys, are we still fine? Can you still hear us?
Yes, that's what matters right now, whether you guys can hear us so that we can proceed. We know that we are working against all the devil. I hope we are able to continue.
Okay, I'm gonna continue, guys. You will catch the train as it moves, so I need to rush and finish.
Yeah, before you rush and finish, let us hope that you are audible.
Okay. Test for me, guys. Am I audible? Is there
Funny
sound?
exercise though, but someone is definitely dealing with us.
And for those who say, why don't we go earlier? We can't. We have tried. We have tried. We cannot. We have a lot of things on our plate.
All right, continue.
So Mngomezulu said in the event that there was no recording, the implication would not be that the court would be at a difficulty to arrive at a conclusion. And the judge said this is a case involving a magistrate in a lower court related to the transcript of a dictaphone and telephone recording, and it went on appeal. And this is what the magistrate should have done. Mngomezulu said the contents of the dictaphone could be submitted and the magistrate himself should have listened in court to the records being played, even if he had to do so with earphones. So the judge said, and even if no other person would have been able to hear the recording, and if the record could be played so as to be reasonably audible to the appellant, his counsel and the magistrate are at one rendering that, in my opinion, should have been done. And the judge said from Jan van Riebeck's times, they are saying that the court must listen. Further, he says in the case of a photograph, the court itself looks at it, whereas the court itself did not hear the recording. Now, this was very interesting because he even had a book next to him, and he was referring to this book with regards to this case where they were using dictaphones and telephones. It must have been from a way back, 1957, he said.
Yeah.
The judge said if the recording could be done so as to be audible to the court and the parties, there's no reason why the judicial officer should listen to the recording instead of being told by some other person that he has heard. Mngomezulu said, "My lord, I still stand by my submission, and I am happy that the court is quoting the matter where there were no rights at the time." This was juicy. This was a clapback I have been waiting for, and I've been wondering why the defense counsel was not reminding him that these cases that you like quoting from were from a time when people of color had no rights. Okay. So I was very happy when he did that, to remind him that these cases that you keep quoting from,
Yes.
they are very worrying, because that time we were not included in this law thing. In fact, people of color were seen more or less like animals, not regarded as human beings.
Yeah.
So the judge said more so today because there are rights. No. Take from 1994 at least. Then up.
Yes.
No. So Mngomezulu said today we are protected by rights, and such rights were violated. And the judge said it's the other way round. There were no rights there. It was the discretion of the judicial officer. Mngomezulu said, basically saying evidence which has been obtained in a manner which violates any rights must be excluded if it would render the trial unfair. Now, Mnisi said that the court needed to hold another trial within a trial to determine the admissibility of the audio recording. And the judge said, I can declare that we are also holding a trial within a trial. Mnisi said, if that's what we are doing, I cannot take it forward. And the judge said the process is continuous. He even said something like, what did he say with regards to Mnisi? That he said that it's intertwined. It's intertwined, this trial within a trial. So Mr. Anonymous already got deep with it to explain it. So Ngumalo said that he followed the same, and Advocate Mshololo was next. The magistrate ought to have explained the rights of the accused regarding the recording, that the recording would be used against you in a court of law before she proceeded with the recording. The audio, which was unconstitutionally contained, should not be played to the court because it contains incriminating evidence. Now, Advocate Mshololo said that the rights of the accused were violated in that, for one, he should have been told that the recording would be used against him in a court if it contained incriminating information.
Yes.
Mshololo said, having listened to the recording, it does contain incriminating information, and the accused was never warned before the recording was made. Arguments on the admissibility of the recording have been concluded. And the judge will be making a ruling. Judge Ratom Hwatling will be making his ruling tomorrow morning at 10 a.m. whether the state succeeded in persuading the court whether the audio recording of the accused number 2 Bongani Ntanzi's alleged confession is admissible. Hwatling will also rule on whether Ntanzi's rights were violated when he was not informed that the alleged confession was being recorded by Magistrate Vivian Grenier. Now, when it was time for Baloyi to make his counter arguments, he used a Key versus Attorney General case.
Yeah.
And he said that, is it a Key Attorney General? Something interesting happened here, and I don't know how many people picked it up.
Yeah.
Where when he's quoting this Key Attorney General case, the judge actually said it first before before Advocate Baloyi could utter it.
Yeah.
I don't know how many people.
Yeah, I noticed that they making sure that we see that he knows the case. It sounded like that.
No, he could be making sure that we see that he knows the case, but Lob Chacharach Lobu makes some of us wonder what is going on. Why are you not letting him finish speaking? It's almost as if you were there with him preparing this.
Yeah.
It's not a good sign. In some of us and our speculations and how sensitive we are with this case, it's not a good look. Just let Baloyi talk for himself. And when he spoke of the case, before mentioning the case, and the judge actually mentions the case, Key versus Attorney General, and I'm like, why can't you let him finish? Just let him finish. Don't give it away that you are also within. You understand? So, Mr. Anonymous, I don't know about you, but I think it's time we let the calls in. I'm sure our callers have a lot more to say and get off their chest regarding what happened today with regards to the heads of argument. And considering the fact that even the internet is
Interneting.
So let's just open the lines so that before it disconnects us again, we are able to have opened the lines for some of our people to come here and talk freely.
All right, let us let you talk, guys. The lines are open. But do not be surprised tomorrow if this man rules against this. We have submitted the basis in which he could rule for the defense to say that, and it will be a right thing, in my own opinion, to do so, because I felt it even yesterday that the rights of the accused were not fully read to him. And that could have even changed the statement that he made. Not even the statement only, even the recording. He could have said certain things that he couldn't say, maybe if he felt that he was under duress. So, knowing that there was a recording that was going to be eventually admissible in court, could have maybe tempted this man to say more than he gave them.
It will be interesting as well to find out from Ms. Grenier during cross-examination why she said she didn't feel safe.
That is if there's going to be a cross-examination in any case. Because if this does not go through, the gist of this case is relying on this. I'm sorry to say, but that's what I think. This recording that was not supposed to be even part of the court, just recording for his own safe. It'll be interesting to ask her though, why did he feel the need to say that? Why was he talking about her own safe? In what sense?
Presence of police.
In what sense did you feel that you needed to record this because of your own safe? Your own safe of what? Losing the statements? Was it losing, or you thought that someone could change the statement? What was the reason for you to record this? Also, let us not undermine the fact that what is reduced into writing is less than what is in the video. So the video is amounting to introducing almost new evidence.
Yeah. That's what Mshololo said in her argument, that it has new evidence. So and he said, I have listened to the recording. I have read the document before the court, and also indicated that in the recording there is an additional information which is not contained in Exhibit JJ, submitting the relevancy of leading the video recording. Hence, my lord, I'm submitting to say into evidence information contained in the video recording is not the same as the document submitted to the court, which is Exhibit JJ, which is the statement that Ms. Grenier made with accused number 2. If you listen to it, as a result, that we continue with the trial within a trial regarding the admissibility of the video recording first, and after the ruling, the court then may listen to the video recording. They want the admissibility to be dealt with first. So that was some of the arguments from Advocate Mshololo that she made. and totally attempted to debunk the Section 217 of Act 51 of 1977 that Advocate Baloyi had used. And also, what was interesting about Ngumalo is when he said that he disagrees with the RICA Act.
In a manner that it was submitted or used, in a context in which it was used, not to say that it disagrees with that RICA Act.
No, he said it wasn't used correctly by the state.
Yes.
The act that is applicable is the Electronic Communication and Transactions Act, Act 25 of 2002. The relevant provision is Section 15, subsection 3 of the Act, so it governs this whole procedure. And the judge said, I'm sure he'll respond to that. I'm sure he'll respond. Did he respond to it? No. Did he?
No, he didn't. He opted to respond to Mngomezulu and Mshololo.
Ziyakhala manje. Ziyakhala.
It is very interesting now because there are people who now I feel like the defense is almost getting better in terms of being stronger almost everywhere. We don't know how long it will take for the judge to show the signs of disrespect that we have seen to Mngomezulu. But I think also the fact that he's a bit older, he must be respected. It's not something that you can just do. And yes, whoever is dealing with the communications, dealing with us, he might be dealing with us.
So the case of S versus Magwaza 2016 volume 1 where the trial,
that's a fresh case
court, yes, because even there was a bit of an argument between Mngomezulu and the judge, where it was like now they are comparing the cases that they have used versus the ones that they are using, and he was saying that the ones you are quoting from are kind of old, and this state versus Magwaza is kind of newer compared to those ones. I mean 2016, and the judge was like those ones are from the higher court, the high court, and this one is from the regional court. What do you think about it?
But it's just it's what we talked about, undermining the levels, and this is the same law. Whether it's high or low, we should apply the same law, right?
Yes, it seems like in his arguments, he doesn't even regard the regional court cases. Yeah, I'm talking about he only deals with high court cases and constitutional court cases. So the weight for him is above. Never mind the violation of people's rights. Just because they are from the constitutional court or the high court, to him, they are more important than. So don't be shocked if he comes and rules and says that the state can use the recording. I'm expecting it.
Yeah, we are sort of expecting it.
So this case of S versus Magwaza, where the trial court and the full court focused solely on voluntariness or the pointing out and the confessions, both were criticized for not touching on the Constitution's exclusionary provision, Section 35, subsection 5, applicable in this case, where there was certainty, reason to do so, the right of an accused to be informed of their rights, and the consequences of an infringement of this right. So Mshololo said, my submission is that we are in a trial within a trial. In respect of Exhibit JJ, the content of the statement has been brought before this court. That content has not been revealed yet, and we have agreed to block the incriminating statements and words in the document which has been submitted before this court. Until the ruling whether the statement has been ruled admissible or not by this honorable court, my submission, my lord, is that the witness, Ms. Crinier, as a magistrate, my lord, when she was taking down exhibits recording in terms of Section 217, she recorded the statement in terms of Section 217, subsection 113, but the case law, which is ACA, which I've just referred this court to, says that the requirement of Section 217 only is not sufficient. The judge said, of course not. The Constitution is applicable. Yes, my lord, said Mshololo. In this case, I submit that above meeting the requirements, if they were met of Section 217, the magistrate, who is the witness, ought to have explained the constitutional rights of the accused. Specifically to the recording, to say above what I'll be taking down in the statement, I'll also be recording, the voice recording will be used in court against you. So those constitutional rights ought to have been explained to the accused. The deponent at the time before the witness proceeded with the recording. My submission is that as we are in a trial within a trial until such a ruling has been made by the court, the video recording, which was unconstitutionally obtained in terms of Section 35(5), should not be played to the court because it contains incriminating evidence, my lord. Why I'm making that submission is because I have listened to the recording. I have read the document before the court, and the state also indicated that in the recording there's an additional information which is not contained in Exhibit JJ.
Which is amounting to submitting new evidence.
Yes. So yeah, that was really good. I was impressed with Advocate Mshololo's arguments.
And for those who are saying that, okay, someone is saying this criminal must be arrested. In fact, they were hired by, he's putting the name, that's allegedly, and that's according to his view. If you think that there's someone who's going to be arrested as a mastermind, then I believe you are delusional.
At this point, ne? Especially if you are following the case.
No, I believe you are delusional.
You are in another world, Mtagabao.
Because there's no such thing. There's no such thing as that. No one.
You are beyond help.
If these people get arrested, they will go down alone.
Yes, they will.
Forget and that there's going to be someone who's going to be arrested, and that person would have been arrested long time ago.
And they're not just going down for this. They have other crimes, some of them. They have other cases that they are currently serving sentences for.
Yes.
So
the person who was only 3 years is Bongan Tanz.
Yeah, Bongan Tanz is the only one that honestly most of us are worried about.
And he was working.
He was working, he had a job. So his life just flipped upside down in 2020. So
there's no one else who's going down?
No.
You would have seen the body language of those people changing if they were really going down. People are free, man. People are moving freely. And there's, honestly speaking, man, it doesn't take you long to actually see that there's definitely, according to me, there was no mastermind there. That's my opinion. There's no mastermind. That means actually there was no gabbies that were sent. So if you want the truth must be inside. That's it. There's no other way around. In your thinking, man, look at these people. They have colors, man, in terms of doing what they do. We're not talking about amateurs here.
No.
Most of them.
No.
We're not talking about amateurs. No one was going to be able to push them and go out of the house. If you got in time to look at accused number 5,
would have ended on that day. Everybody. They don't leave anyone.
And the other accused. Do you think that they would have let just a small Nyana boy push them around?
No.
Come on, man, guys.
No, especially if there was 5 of them, nobody was gonna survive.
No way. Bella, if there was such a thing. If
For
they
those
said
who
this
are conflicted, there's a video on the tab under videos where we covered Warrant Officer Makubo's life being in danger. And in that video, there's also a snippet of what accused number 5 went to prison for.
Yes.
Just go through that story and understand that if they really, really did this, none of those people in the house would be alive today.
This is not some boy from the
We
street.
are not playing here.
We are talking about serious people.
We are talking about serious.
If you think that they were there,
Nkabis.
if you think that they were there, and really they managed to pull this crappy job where the bullets and whatnot and the heads were left behind.
Yeah, no.
Then you don't know what you're talking about.
No.
You don't know what you're talking about. You've got to think again. So I mean,
if you are still stuck there,
warrant-
only God can help you at this point.
Accused number 5 was arrested by Warrant Officer Makubo for those crimes that he
Yes.
allegedly committed, or even commit because he's in jail for. Then when Warrant Officer Makubo is dealing with this case, he goes to now face the court because of something that happened some days back, right? Mm-hmm. And allegedly fearing for his life now.
Yes.
As I mean, I think it was Veiws who said it.
Veiws also confirmed it.
Where do you think
It was reported before, and it's Senzo Meyiwa confirmed.